let's talk about trademarking your brand. Let's say you're a business owner, you're an entrepreneur, and you're thinking about how to trademark your brand. Let's talk about that. So here's an overview I want you to pay attention to. The thing is that registering a trademark for your company is a big step that actually helps your brand identity from misuse or theft, right? Now, registering a trademark is a fairly straightforward process that you can complete in just a few easy steps. And into this conversation, I will really explain everything to you. But let's first go back to a trademark 101. What is a trademark? Let's quickly understand what we're talking about here. So according to the United States Patent and Trademark Office, USPTO, a trademark is a word, phrase, symbol, and/or design that identifies and distinguishes the source of the goods of one party from those of the others. So it's a legal protection you can use to take legal action against an entity if they are misrepresenting your brand or using it without your consent. So a trademark is different from a patent, which really basically governs technology and ideas. We have had an entire show dedicated to patent versus trademark versus copyright. Okay, so something patented cannot be used in another entity's products or services without that entity's permission. A trademark is also different from a copyright, which applies only to artistic works, and entities other than the work's copyright holder may not copy actually the work or use it for profit without the copyright holder's permission. So if you do this, you basically are infringing the person's copyright. Okay, so now let me give you the steps to trademark your company name. So trademarking your company's name is not as simple as filing for an LLC and may take more time than you can imagine. So the first step here is you need to search. So you need to search the federal database to ensure the name you want to trademark is not already protected as a trademark. And you can do this with a USPTO trademark electronic search system, also known as TESS. And you also want to search for, you should search not only for the name you want, but also for similar names. Your registration could be denied if the name is too similar to a name already registered within the same class. Okay, so while this sounds straightforward, it can be complex. Okay, very important to think about things. Boss, welcome back to the show. It's really a pleasure to have you here. Make yourself comfortable. You are going to enjoy today's conversation. So the first step here is you need to search, right? You need to search for your name. You go to test and you search for the name to see if the name is already used. The second thing is you need to apply. So once you have searched and cleared the name you want to trademark, it's time to prepare your trademark application. You can file for a name already in commercial use or with an intent to use the name in the future. And so when we talk about trademark application, now the document is fairly long. And sometimes people actually go through, entrust the process to a lawyer. But I can reassure you that you can do it as well. You don't need to have a JD or a PhD in law to really file a trademark application. A trademark application has 10 components. So you have the name and address of the applicant, the citizenship and legal entity of the applicant. So when we talk about legal entity, here we're speaking about LLC, S corporation, C corporation, partnership, so general partnership, limited partnership, whatever. Okay, and a name and address for future correspondence. This doesn't have to be the same as the name of the applicant. You also have a drawing of the desired mark. If you are only applying for the name and don't want to include a design element, you simply type in the name. You need to have a thorough description of the mark you're trying to protect. You got to have a specific list of services or goods covered by the trademark application, because see, federal authorities, USPTO officials wants to have a clear idea about the mark you're trying to protect. So the clearer you are, the better. You also need to talk about the class of services or goods. You need to have an example of the mark in use as well as the dates it was first used. Again, the more information you give to authorities, the better, because this is in your favor. You also need to have a dated signature from you or an authorized representative. If you have a trademark application that is not signed, it is not considered valid. Okay, so you gotta sign it. You also need to have the appropriate, you need to add the appropriate fee for the type and number of classes included on the application. Boss, I want to quickly remind you of today's topic. We are having a conversation about how to trademark your brand. So the next step here is you need to file, right? So first step, you need to search for the name to make sure it is still available. Number 2, you need to apply. Number 3, you need to actually file. So once you have completed the application, you have actually 2 filing options. You have what they call T's Plus and T's Standard. So the Plus option is less expensive and more streamlined. It's also it has a lower rate of rejections. However, if you need to create a custom description, like if you need to create a custom description of your services or goods that is not available in the preset list, Plus provides the risk associated with the standard option may be more beneficial for your situation. So once you have submitted your application, you will actually receive a confirmation receipt from the USPTO and a serial number that you can use to check the status of your application in the Trademark Status and Documents Retrieval TSDR portal. Okay, so this is very important. So the key takeaway here is that to register a trademark, your brand name, you need to search the test database for similar brand names, fill out the trademark application, and submit it to the USPTO for review. So I think I've already explained to you the difference when it comes to copyright, right? But one thing you need to understand also is that there is a slight distinction between trade name, trademark, and service mark. So a trademark protects goods and a service mark does the same for services. However, the word trademark is sometimes used for both types of marks. Both are designed to limit the ability of competitors to mislead consumers with false claims of where a product or service originates. A trade name is what's used in place of the official business name. This is often indicated on paperwork with the phrase "doing business as" DBA. It is used when the business name is considered too lengthy or when the desired name is too close to one that already has a trademark or service mark. Note that a trade name does not indicate the legally responsible entity behind the service or product. So when we talk about trademarks, there are 4 types of trademarks. You have a descriptive mark, which describes at least 2 elements of a product or service. A suggestive mark implies a meaning rather than stating it outright, such as the Target logo. A fanciful mark is a word, phrase, or logo unlike any other, such as Sony. And you have an arbitrary mark is a word, phrase, or logo from everyday language used in a unique way for a business. So Amazon and its hybrid smile arrow logo are great examples. So the big question is, should you trademark your company name at all? I mean, like right now, is it something that is it really worth the additional expense? It's a conversation you need to have. Now, it's not really necessary to register your name to receive protectable rights. In the US, for instance, you are granted common law rights to a mark simply by using it as part of your business. This means that you could begin using it and enforce your ownership of it through documentation of being the first to use it commercially. However, there are limitations on your rights with a common law trademark. Okay, so registering for a federal trademark has a number of advantages. Most importantly, it gives you legal ownership of the mark and the exclusive rights to use it anywhere in the nation as it relates to the goods and services you listed during registration. Common law rights are limited to the immediate geographic area in which you are operating, and registering the name with your state only protects your rights within the borders of that state. So basically, if you are having a 50 state sort of business model, you need to actually register things at the federal level. So when you register your mark with a USPTO, there will be a public notice stating your ownership, and it will be listed in the online database. So with a federally registered trademark, you also have the option to register your trademark with the U.S. Customs and Border Protection to keep foreign goods from being imported with the same name. Okay. You'll also be able to use the federal symbol R instead of the less enforceable TM mark. So this is kind of important. So the name of your company is the main way you present it to the world, right? Imagine someone else using your company's name to make offers that are antithetical to the mission and values of your business. If you want to afford your business the maximum legal protection, you will need a trademark. And so when you file for a trademark that covers only one classification, each additional classification must be noted in the application and will incur an additional charge. So this is kind of important. And so based on our research, there are right now 45 classes to be considered. For example, if your business produces vehicles, you would want a Class 12 trademark. If you additionally wanted to sell clothing with the name of the same company on it, you will need to have a Class 25 trademark. Consider exactly how you will be using the name to determine which class or classes you should list it under. Boss, I want to quickly remind you once again of the topic that we are talking about today. I'm talking to you about how to trademark your brand. So when we talk about brand trademarking, let's really talk about who should trademark his or her business name, right? It's one of those things where it's all about the way we actually analyze it. It has to, you got to think about return on investment, right? It's got to be an ROI component here. If your business, for example, if your business has a unique name, it can be trademarked as long as it's not too similar to another name that's already received the trademark. For example, if the name is too vague, like the ice cream shop, it is unlikely to be eligible for a trademark. So this is kind of important. And so something like, let's say Iguana ice cream or John Doe ice cream will be more likely to receive a trademark because it joins common words in a unique way. It's also important to consider the geographical area you will be serving, right? So if you're in New York, for instance, and you're thinking about common law, this will be different from if you are seeking something federally enforceable. So the common law trademark protection that you automatically receive from using the name is restricted to your immediate geographic area. If your business serves multiple states, you will definitely want to apply for a trademark to protect your business. Because again, when we talk about trademarking stuff, we're talking about legal protection because you never know. You do not want, as I said earlier, you do not want somebody to actually do things that are antithetical, that are contradictory to your business model. And if you have several product lines within your business that also have unique names, you may want to trademark those as well. Okay, so this is kind of important. So for example, Ford, the motor company, is a trademark of the Ford Motor Company, which also has trademarks for lines of vehicles such as the F-150, the Mustang, the Ranger, and the Explorer. So again, it's all about affording multiple layers of protection. Okay, so it's very important. So make sure that you apply for a trademark if you want to have a federal protection, because the common law trademark protection that you automatically receive for your business name is restricted to your immediate geographic area. So if you're actually thinking about trademarking your brand, and you're thinking about, well, should you get a trademark or LLC first? This is a very good question. So whether you should register for a trademark or an LLC first largely depends on your business goals. Because see, when we talk about a trademark, we're not talking about, you can't really compare an LLC to a trademark, because an LLC is a limited liability company. It is a business structure classification within the US that describes a private limited company. It is usually issued by the state in which the company operates, although you can receive an LLC from any states. An LLC registration usually takes less than a day to process, while a trademark takes an average of 3 months. Okay, so right off the bat, you have a duration being, there's a big delta in terms of duration here, okay? And if you want to begin operating immediately, it makes sense to register for the LLC first. If you have plenty of lead time and are more interested in securing your federal rights to the name before you put it out into the world, out of fear that it may be co-opted by someone else, then it makes more sense to apply for the trademark first. So it's one of those things where you have to really see what really works for you. Now, does your business need a trademark registration right away? Well, your business does not need to register for a trademark right away. Typically, you'll need to be able to show use in commerce when registering for a mark, which means that you should be able to prove it was being used before you could register it. However, there is the option to apply for an intent to use ITU trademark, okay? And if you proceed with an ITU trademark, you still have to demonstrate your use of the mark in commerce in completing the documentation and paying the additional fees within the allotted time frame prior to the mark's registration. There are only 3 periods within which you can claim use in commerce: prior to approval for publication, within 6 months of the issuance of the Notice of Allowance, the NOA, and within the time granted by an extension. So you can establish use in commerce in several different ways, including the following: placing the mark on your goods sold on your websites for goods sold, using the mark in association with services being sold. And there are 3 types of commerce under federal law. You have foreign commerce, you have territorial commerce, and you have interstate commerce. What is not typically acceptable is actually intrastate commerce, meaning business that is limited to the borders of a single state. If your business cannot yet prove you are using the trademark in commerce, or if you will not be able to prove it within the confines of the ICU process, there is no reason to apply for the trademark first. So this is the type of calculation you need to go through before you file federally. So the thing here is that, if you're going through the process of registering your business and you want to know if someone else already has rights to a mark, there is a very simple way to find out. Okay, TEST makes it easy to search the federal database of trademarks in various ways. The basic word mark search allows you to search names, words, or phrases that have received a federal trademark. So if you're really confused and you're like, let me just find out if somebody else has already registered my name, you just go to TEST for it. There's also the option to browse the directory or individual fields within the database. So if you're not really sure exactly what might have been trademarked, but a general date, you can search by registration or publication date. And if your registration is accepted, how long that registration is valid, well, it really depends. But in general, a trademark registration is valid for as long as you are willing to maintain it. Once a trademark is issued, it doesn't expire as long as it remains in use for the registered purpose. Okay. Now, that's one thing I need to really clarify here. A trademark does not grant you ownership of the word, phrase, or image. It gives you the right to that word, phrase, or image as it is used to identify the services or goods listed in the registration. However, using it is not quite enough. You must give the USPTO proof that the trademark has remained in use by filing a Section 8 declaration between the 5th and 6th anniversary of the registration. This is a simple sworn statement, okay? And it's really important because you want to remain valid and active in the authorities' book. And so upon the registration's 10th anniversary, actual proof is required. This can be an image of your products or service using the trademark. You must do this every 10 years, otherwise you lose the protection. And some people find it so complicated, find the whole process too complicated, so they actually just hire a trademark attorney. Okay, so your choice to hire a trademark attorney to assist with your application may depend largely on your budget. So it's one of those things where you got to ask yourself, well, is it worth it? And what we have found in our research is that if you actually go through a trademark attorney, you are 50 to 60% more likely to be approved because, again, it's really so you have a professional that's taking care of things for you. But the big question is it worth it to spend money on an attorney to increase your application's chance of approval? Or only you can really decide. Okay. So to trademark or not to trademark. So this is really the question, right? So trademarking your brand is great if you are worried about people using it unfairly without your permission. It's also great if you are expanding to operate in several states, but a trademark is never fully necessary. It just offers extra protection, and obtaining it can be a long process. That protection, though, can suggest that your business is official, and that's a great way to build trust among customers. Thank you so much for your attention. I really appreciate it. In today's conversation, I was just talking to you about how to trademark your brand. So the 3 steps here: you need to search the test database, you need to apply, and you need to file. And then I give you a few pro tips. And when it comes to making the whole process a lot smoother. Thank you so much. God bless you. I'll see you next time. But until then, remember, stay marvelous.